members. I call this meeting to order. Welcome to meeting number 36 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to Standing Order 1082, the committee will study the nomination of the Honourable Glenn D. Joyal to the Supreme Court of Canada. Today's meeting is taking place in a hybrid format pursuant to the standing orders. Members that are attending in person in the room and remotely using the Zoom app. I would like to confirm that sound tests were conducted and were successful. I would like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either floor, English, or French. For those in the room, you can use your earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best as we can, and we appreciate your patience and understanding in this regard. With us today, we have the Honourable Sean Fraser, Minister of Justice, and the Attorney General of Canada. Welcome, Minister Fraser. We also have the Independent Advisory Board for the Supreme Court of Canada Judicial Appointments, Maureen McTeer. Welcome. We really appreciate you taking the time to be here as chairperson. And we also have from the Office of the Commissioner for Federal Judicial Affairs, Marc Giraud. Merci, Commissioner, for being here today. We appreciate that. We'll start with 5 minutes each for your opening remarks. Minister Fraser, please go ahead.
Thank you very much, Madam Chair. Thank you so much, everyone. And before I begin, let me thank Ms. McTeer and Monsieur Giroux for their participation in the process, which has led to today, where I am honoured to be here before you in support of the Honourable Glenn Joyal, who has now been nominated to the Supreme Court of Canada. Chief Justice Joyal is an exceptional jurist, and I'm confident in his capacity to uphold the highest of standards in all facets of the position. It includes thoughtful contributions to the evolution of law, exceptional service to our country, dedication, professionalism, and ethical excellence. I offer my heartfelt congratulations to Chief Justice Joyal, and I look forward to his appearance before parliamentarians later today. La nomination de juge en chef Joyal vise à pourvoir les...
The appointment of Chief Justice Joyal follows the retirement of Justice Martin.
Of service to our country, Canada is better for your many varied contributions. La nomination en temps opportun des candidats d'exception.
The appointment of exceptional candidates is essential for the good running of our judicial system, and I want to make sure that judges are always nominated on time. There are two aspects to this process, the selection process and the advisory committee. I will give you an overview of both aspects, and then we will hear Ms. Maureen McTeer, who chairs the advisory committee, and she will be giving us opening remarks.
Supreme Court appointment process generally and our unique role. Today we're taking part in the crucial work of upholding public confidence in the administration of justice. Trust in our judges is essential, as is confidence in the integrity of the process by which they are selected. This is now the 7th time this process has been used following its introduction in 2016. The Prime Minister launched the current process on March 30th of this year, with the application period closed in late April. Suitable candidates would be jurists of the highest caliber who not only demonstrate superior knowledge of law and analytical skills, but who are aware of and sensitive to the social context in which legal disputes arise. Commitment to public service, respect and consideration for others, and irreproachable personal and professional integrity are key. The Independent Advisory Board was also charged with ensuring recommended candidates were functionally bilingual and reflective of the diversity of Canadian society. In accordance with the well-established custom of regional representation on the Supreme Court, this selection process was advertised as open to all qualified applicants from Western and Northern Canada. Charged with rigorously assessing candidates based on public qualifications and assessment criteria, the nonpartisan Independent Advisory Board is at the heart of the selection process. The board's 8 members, including the chair, reflect Canada's diversity and bring their varied backgrounds and viewpoints to the ultimate goal of identifying the best candidates. This esteemed group of Canadians includes government nominees as well as those put forward by a range of other organizations committed to serving Canadians by upholding the rule of law. Madam Chair, I had some additional time that I was contemplating. I did want to save space for others. It was at 5 minutes for each. Perhaps I will take an opportunity to provide the floor to Ms. McTeer to the extent there's a moment at the end to conclude. I'd be grateful for the opportunity.
Thank you
Ms.
very
McTeer,
much.
please.
Please go ahead, Ms. McTeer.
Well, thank you, Madam Chair, members of the committee, Minister, Monsieur Giroux. Good morning, all. C'est pour moi un immense privilège d'occuper le poste de présidente du comité.
It is a privilege for me to chair the Independent Advisory Committee on the appointment of Supreme Court justices, and I am pleased to appear this morning.
By 7 colleagues, namely Ariel Bellegarde, a lay member nominated by the Minister of Justice, Aimé Kraft, nominated by the Indigenous Bar Association, Justin E. Kingston, nominated by the Canadian Bar Association, Justin Robichaud, King's Counsellor, nominated by the Federation of Law Societies of Canada, the Honourable J. Michael MacDonald, former Chief Justice of Nova Scotia Superior Court, nominated by the Canadian Judicial Council, and Dean Laura Spitz from the University of Calgary's Law School, nominated by the Council of Canadian Law Deans. Chaque membre a apporté à nos travaux.
Each member brought to our work a background of professional accomplishment and a vast array of experiences and regional, community, and national perspectives. We share with each other a profound commitment to the rule of law, a commitment to the institutional significance of the Supreme Court of Canada, and to the best interests of our country.
Mandate was to identify candidates from applications received who would be suitable for appointment to the Supreme Court of Canada for the Western region to fill the vacancy created by the retirement of Justice Sheila Martin of Alberta. And I add my comments to those of the Minister. I've known Justice Martin since I taught at the law school at the University of Calgary, and she was dean, and she was indeed an exceptional jurist. The process was launched on March 30th of this year and was open to candidates from Western Canada, namely Manitoba, Saskatchewan, Alberta, British Columbia, Yukon, Northwest Territories, and Nunavut. The Western region has 2 justices on the Supreme Court of Canada. À la suite du lancement du processus,
Following the launch of the process on March 30th, the Commissioner for Federal Judicial Affairs communicated with Canadian legal and judicial organizations and asked them to use their networks and their knowledge of the judiciary and legal community to identify qualified candidates and encourage them to submit an application.
Candidates were invited to submit their applications by April 27th of this year. In all, 9 applications were received. In order to be considered, each applicant was required to fill out an extensive questionnaire. A copy of such a questionnaire is available on the Commissioner for Federal Judicial Affairs website. Relevant portions of Chief Justice Joyal's application are also available on that website. Les membres du comité consultatif ont été nommés par...
Advisory Board members were appointed by an order in council on May 13th, and we all had a meeting on Teams to immediately begin our work. During the days that followed, each board member independently reviewed all the applications in depth.
Le comité...
The board then met in person in Ottawa for 4 days. These were 4 intensive days, and they took place from May 20th to May 23rd.
By the Prime Minister was to identify candidates who are jurists of the highest caliber, bilingual in both of Canada's official languages, and representative of the diversity of our country, and who possess the experience and the judgment required to serve on our highest court. In carrying out this mandate, the Advisory Board was guided by its terms of reference, Section 80, of which required it to consider the institutional needs of the court in order to evaluate how each candidate could best meet the court's current and future needs. To ascertain this, we met with Chief Justice Richard Wagner at the beginning of our deliberations. Dans ses conseils, le juge en chef a souligné
In his advice, the Chief Justice emphasized the importance that the chosen candidate possess deep legal and judicial experience across diverse areas of law, that the person be collegial in dealings with fellow justices, that they be willing and able to undertake a grueling workload, and that they possess the ability to represent the court in national and international fora.
Reviewed all applications exhaustively. The questionnaire, as you will see when you read it, goes well beyond a traditional curriculum vitae, and it is very thorough. In addition to addressing personal skills, experience, and professional qualities, it delves into professional and non-legal experience, community involvement, and written work. À l'issue de ces délibérations,
Following deliberations, the advisory board agreed to create a list of candidates to be interviewed. We prepared together a list of questions which would be asked of each candidate, and we began calling references from both judicial and non-judicial areas. And these references were familiar with the candidate's work and character, including chief justices. Members of the board conducted these discussions directly by phone in teams of 2 for each call, following a consistent and structured approach in order to ensure fairness and comparability across the different candidates.
4 candidates were invited to participate in personal interviews in Ottawa, which were conducted here on May 23rd. The advisory board assessed these final 4 candidates against well-established criteria, including extensive and superior knowledge of the law, intellectual contributions as witnessed by their legal writing and judicial opinions, analytical ability, integrity, collegiality, judgment, and the capacity to begin immediately to perform the work of a justice of the Supreme Court of Canada. À l'issue de leurs entrevues,
Following the personal interview, each candidate then undertook a language test. It was professionally administered in order to confirm the candidate's functional bilingualism. This bilingualism is defined as understanding written and oral texts and arguments in English and French, and the ability to converse with colleagues and litigants in both of Canada's official languages.
Comprehensive review and extensive deliberation, the advisory board reached unanimous consensus that it should recommend only 2 candidates for the Prime Minister's consideration. A report of our decision was then provided to the Prime Minister and to the Minister of Justice for their consideration and decision. Je suis heureuse que le juge en chef Joyal.
I am pleased to acknowledge that Chief Justice Joyal from Manitoba was selected from the names we provided to the Prime Minister. The board found Chief Justice Joyal to be an outstanding candidate, distinguished by his exceptional and extensive legal expertise, by his depth of professional and judicial experience, and his interpersonal qualities.
We were particularly impressed by Justice Joyal's thoughtful, articulate, and forward-looking perspective on the role of the Supreme Court of Canada and its many challenges, as well as his strong commitment to public service. I would be remiss not to mention here that all of our board members are deeply grateful for the exceptional support we received from the Commissioner, M. Giroux, je vous remercie, of Federal Judicial Affairs, and his highly skilled and dedicated staff. I'm going to take one of your secretaries, if I can, to help my husband, whose contributions were invaluable to the successful completion of our mandate. I've enjoyed the challenge of acting as chair of this independent advisory board and to work alongside such dedicated and thoughtful colleagues throughout this process. Their spirit of collaboration, professionalism, and shared commitment guided our work throughout and made this entire process a success. Si vous avez des questions par la suite, je me ferai un plaisir de
I'll be
vous
happy to answer any questions.
Thank you very much, Ms. McTeer. I know that you went way over your time, but we appreciated the process. Monsieur Giroux, do you have opening remarks to make also?
This will assist you, perhaps, Madame la Présidente. Je n'avais pas prévu faire de déclaration d'ouverture. Je suis plutôt.
Actually, I hadn't prepared any remarks. I'm here to support the Minister and Ms. McTeer as they perhaps might need.
It was an honor again for me and my officials to administer this process, the sixth for me, and to assist the Independent Advisory Board and the proposed nomination of an exceptional candidate in the person of the Honourable Glenn Choya.
Thank you very much. Minister Fraser, did you want to take minus 30 seconds out of what's left?
Look, only to say that his resume is publicly available. We are very lucky to have individuals of Chief Justice Joyal's character and professional record step up and put their name forward to serve in this capacity. I'm looking forward to seeing the difference that he's going to make, and I hear without reservation about the quality of the individual that we are seeking to have appointed at the Supreme Court of Canada. Thank you.
Thank you very much, Minister Fraser, Ms. McTeer, Monsieur Giroux, for being here today. We'll start with our first round of questions for 6 minutes each. We'll start with Mr. Brock. Please go ahead for 6 minutes, Mr. Brock.
Thank you, Madam Chair, and good morning, and thank you to Monsieur Giroux, Madame McTeer, for your appearance today and your assistance in this process. Always good to see you again, Minister Fraser. I'd like to start by echoing both Ms. McTeer and the Minister's comments with respect to retired Justice Sheila Martin. I wasn't aware, Ms. McTeer, that you actually taught at my alma mater. It must have been after I left. But just before, maybe? Okay. I graduated in 1990. I don't know when you sat and taught. But nevertheless, Justice Martin taught me torts, so I have a very, very affinity towards that particular justice. So thank you for those comments. And thank you, Ms. McTeer. I know you went beyond the 5 minutes allotted, but I think it was helpful for all of us to understand the process. And as a result of your thorough explanation, a lot of the questions I was going to be put to you have been answered. But there's a couple of loose ends. The application itself, the qualifications on the website speak about current sitting judges in various courts and across provinces and territories. But it also provides a criteria for simply a lawyer with 10 years experience in a particular province or territory. I hearken to your comments about Prime Minister Carney, whose mandate was to choose jurists of the highest caliber. Did that preclude any consideration of the 9 applicants who made application for this vacancy? Were any of those applicants simply lawyers with at least 10 years experience?
No.
Okay. Have there ever been applications that you are aware of during your tenure of lawyers with 10 years experience or more applying without being a judge?
Well, Madame la Justice Cote, for instance, on the Supreme Court now, came directly from practice. The court needed at that particular moment someone who had extensive experience in corporate and commercial law, and she had an outstanding reputation and was chosen. So that's one. Obviously, Chief Justice Borolaskin came directly from academic, and there have been others. Maybe Monsieur Giroux can provide other names. But certainly it's perhaps, for me anyway, something that that we might think about, because this is the Supreme Court of Canada. I always liken this in a sense to a medical interview. If you're on a medical board, a hospital board, and you're looking for a chief of surgery, you would assume 2 things at least. One would be that it's a doctor who applies, but more important, it's someone who's done surgery. And so I think it's invaluable to have the judicial background. That's not to disqualify others, but this is the highest court, and whoever is chosen has to hit the ground running because, I'm sorry, I'm
My
taking
time
up
is very
your time.
limited. I'm
Mhm.
sorry to cut you off. You also reference, and it may have been Justice Fraser who referenced this, that parts of Justice Joyal's application are accessible to the public. Were there any aspects of his application that would not be accessible to the public?
Mr. Giroux?
Yes, Mr. Brock. Essentially, any personal information related to very personal related information related to the candidate would not be accessible. Otherwise, it's rather complete.
Okay, to the minister, in 2021, as Chief Justice of the Manitoba Court of Queen's Bench, Justice Joyal issued a practice direction compelling that province's lawyers to state their pronouns in court at the start of proceedings. It was not optional. As a lawyer minister, you will surely remember that it was always and has been customary and the practice for justices across this country to refer to lawyers appearing in courts as simply counsel. Is this Liberal government expecting that identity politics will extend into the Supreme Court of Canada as a new practice direction?
Thanks very much, Mr. Brock, for the question. The short answer to your question is no, but more specifically, it's a matter of independence for the courts, in my view, to determine not only the substantive legal decisions that they make, but to control their own processes as they see fit to administer justice in the most appropriate way. To the extent that the actors who are empowered to make rules about the processes that courts ought to follow, I think it's best for those who are actually on the ground in the courtroom to be able to make those decisions free of influence from the federal government.
One last question, Minister. In 2019, Justice Joyal was rejected as a potential Supreme Court pick, despite being recommended by then Justice Minister Jody Wilson-Raybould. Now, we all know this wasn't the first time that Prime Minister Justin Trudeau disagreed with a decision by his Justice Minister. Trudeau objected to a speech given by Justice Joyal in which he decried the constitutionalizing of more and more political and social issues into fundamental rights. Is that position problematic for this Liberal government?
I have considered in depth the record of service that the Chief Justice has offered to Canadians in its totality. Between myself and my team, we have reviewed every one of the decisions that he's authored, a number of different speeches. The collective, the sum total of that review, including public speeches he's given, gives me a great sense of confidence that we are making a top-tier pick for the Supreme Court of Canada, and I say that with no hesitation.
Thank you. Thanks very much. I will now move on to Ms. Latanzio for 6 minutes. Please go ahead.
Thank you, Madam Chair. And can you please signal to me when I have 1 minute left, as I will cede my time to 1 minute to Mrs. Begum. Thank you. Monsieur Giroux, Minister Fraser, and Ms. McTeer, thank you so much for being with us this morning and, of course, for partaking in this very important exercise. Public confidence rests partly on Canadians trusting the selection process is fair and free of partisan influence. What safeguards are present in the appointment process which give Canadians that assurance?
Who would you like to take the question?
Ms. McTeer.
Well, I feel that the system actually is very transparent. Anyone who qualifies within the application process, which is available online to anyone, any person who's practicing law and member of the bar for 10 years in any of the provinces and territories that in fact are open, say in this case Western Canada, can apply. But also we have an independent group. Our group is independent. We don't carry a brief for anyone. In fact, one of the first things we did was ensure that anyone was to inquire whether anyone had a personal relation with any of the applicants or was carrying a brief, if you will, for any of the applicants. And of course, the answer was no, and so we proceeded. So that's, I think, pretty strong evidence that the system itself the process itself is very transparent.
And confidentiality is also a key part of the selection process and one that both protects candidates and encourages applicants to come forward. So how does the board balance that confidentiality while still giving Canadians enough visibility to have trust in the process?
Well, the confidentiality element, I think, is absolutely essential to the process. I took an oath, as did my colleagues on the board, of confidentiality. And I must say here how concerned I was when that confidentiality and respect for the applicants, which to me is absolutely essential, was breached by unknown, apparently anonymous people who had access to some of the information and who decided to share it with the media. The questionnaires you will see are very intense, and they contain personal information which is not, which someone will include on the assumption that it is confidential. The transparency issue, I think, handles the concern between the public's interest in knowing information and the actual need, if you will, for confidential information to be kept confidential.
The appointment process and assessment criteria are public, as you mentioned. A candidate's moral courage and open-mindedness are among them. How would you go about assessing these more abstract qualities of the candidates? How is that done?
Well, we tried very much through not just the written material and the phone calls to various references, but also those who were going to be on the so-called short list had the opportunity to come before us. We together, as a team, had 10 questions which we asked each of the people, the candidates rather, and from there you get a pretty good idea of combination. We were working under time pressures which were very intensive, so we were working very intensively, and I believe that is achievable and was achieved. We don't, obviously, if someone has a problem, if you will, with anything, we would have been able to ferret it out during our various discussions and research that we were doing.
Thank you. And if a candidate's prior expression of an opinion on an issue likely to be heard by the Supreme Court of Canada is not a disqualifying factor, how do you assess their ability to remain open-minded and render fair and impartial decisions?
Well, that was usually based on their past actions, their past experience. Mr. Justice MacDonald, in particular, having served as a Chief Justice, was always having a focus on collegiality. How do they, in fact, work with other people? How do their opinions, can their opinions be molded? Or are they so set in stone that no matter what happens, no matter what the case or facts are, that they will refuse to change? So that's just, I believe, something that sometimes it is the luck of the draw, if you will. But on the other hand, I think we had a pretty thorough investigation of all of these things. And I'm quite pleased that we were able to accomplish what we did.
Thank you. So that brings you to the 1 minute you asked me to give you.
Go ahead. Thank
Okay.
you.
Ms. Begum,
Thank you,
please go ahead.
Merci beaucoup. Good morning, everyone. Thank you so much for being here this morning. I'll also ask Ms. McTeer. You spoke very thoroughly in terms of the explanation of the process, and one of the things you mentioned, along with it being an important role and of the highest caliber, it must reflect the country, reflect Canada. We know that Justice Martin was from the West, and obviously the preference was there. Can you speak to the importance of that reflection that we must have justice from Western Canada, and why that was necessary?
Well, it's required under the Supreme Court Act, so that's why it was only open to people who were members of the bar or judges from Western Canada, and that's an extensive piece of geography, as I've noted, in terms of the number of provinces. If you're asking a question specifically, I'm not sure, is your question about diversity or about diversity? Okay. Well, we had it was interesting, from the 9 applicants, there was a great diversity. I think that whole language of diversity is under discussion again as to its broader meaning. There are some who interpret it narrowly as to, and there are others who, as Mr. Joyal will show this afternoon, I am sure, have a sensitivity to the diversity and an understanding of the diversity of the country. And of course, if you look, we will be having a public report, but I just add here, if you look at the law schools, because it's one thing to stop at the Supreme Court level and say, okay, well, we have to have a diverse, but if you look at the law schools now across Canada, you'll see that the student population does represent the modern face of Canada. And as Madam Justice McLaughlin said, when asked the same question with respect to women on the court, it was clear in her answer that she said the same thing. Look to the schools. At that point, almost half of the law schools were women. And we will trickle up, was her point. We will trickle up to the point where we will be not just on the Supreme Court of Canada, but perhaps even the majority, which was a wish at the time. So I'm not concerned as concerned. And I have no doubt that in terms of the notion of diversity, the understanding of the country, Mr. Joyal is going to be an excellent jurist.
Thank you very much. That was way over time, but I didn't want to interrupt there. Monsieur Fortin, pourriez-vous commencer pour 6 minutes, s'il vous plaît?
Mr. Fortin, you have 6 minutes. Thank you, Madam Chair. Ms. McTeer, Mr. Giroux, Minister, thank you for being with us this morning. I'd like to start by saying that given everything I read about Justice Joyal, I would no doubt have come to the same decision you did. So, no objections, certainly not at this time. With respect to the process, I did have some questions that came to mind, and perhaps I could ask Ms. McTeer. So we heard that there were 9 applications. So out of the 9, could you tell us whether there were any members of the Bar of Saskatchewan who submitted their application? How many? The committee is going to publish a report in the month following the appointment, and there will be some information about other applications. Thank you. Ms. McTeer, with respect to the selection process, I understand that you proceeded in a way that had open communication with judicial experts. Did you get opinions from the Government of Canada, or did you get them to generate applications? So we called references, and those references were shared by the candidates themselves. In one case, there was an additional reference that hadn't been included initially, but that happened afterwards. And prior to that, Mr. Giroux had conversations with people from all the Western provinces. The idea was to have as many applications from qualified candidates as possible. But in the reference exercise that I took part in with my board team, there were all sorts of people. Well, thank you for that. I appreciate the answer. It does help me. But I mainly wanted to know whether you consulted the provinces. So did you ask, for example, the premier of a given province what the criteria would be for a judicial appointment that would represent the province well at the Supreme Court? Did you try to generate applications from those provinces? Was there any effort made in that regard? No, not by me. I would just like to clarify one thing.
The application process closed. When we did have the benefit of some of the work of the advisory board, which operated completely independent of our team, my office did engage in some consultation with attorneys general in the western and northern provinces, as well as the chief justices of those jurisdictions from which an applicant would be eligible to be appointed. So there was engagement at a level other than a national level with specific focus on the western and north regions. But that was not to generate applications, but to get feedback on some of the potential appointees.
Et quand vous dites to get feedback, vous avez soumis des...
So you say to get feedback. So did you submit the names and request a reaction, or did you ask the provinces to make suggestions? So how did that work exactly?
I've also left out the Chief Justice of the Supreme Court of Canada. It was to understand if they had experience working with some of the individuals, if they had characteristics that would be important for a person that could be chosen. It was not with a view to have them come up with new names to go find people in the community, but instead to ensure that the choice that we're going to be making would be informed by the characteristics that those other players in the consultation process expressed. My recommendation, independent of the advisory board, both would have gone to the Prime Minister, and he would have the benefit of the duality of that process.
Si vous me permettez, M. Fortin, Madame la Présidente, j'ajouterais simplement qu'au début du processus...
If I may add, at the outset of the process, there's a long list of organizations where there's outreach and consultation in order to generate applications. I'm sorry to interrupt you, Mr. Giroux. I have very little time, about 1 minute left, but thank you for that addition. Minister, did some provinces or some governments object to certain applications, or from the get-go were they all good?
I'm not aware of any objections to specific applications. Not every one of these conversations was with me personally, but based on my review of the materials and the conversations I did have, there was no suggestion that there was one candidate that should not be named. The conversations, frankly, more often revolved around the characteristics that would make a good appointee, rather than people ranking their choices as one might normally when you see.
Mais je comprends que vous n'avez pas demandé. Donnez-moi une liste de caractéristiques.
But so you didn't ask for a list of characteristics or a list of names. That wasn't part of the process, if I understand.
Oui.
Est-ce que vous voyez que ça devrait l'être?
Do you think this should be part of the process, Mr. Fortin?
But we'll come back to the same line of questioning.
C'est toujours la prochaine fois. Je suis habitué, Monsieur le Ministre. Merci.
That's okay. I'm used to it, Minister. We'll get back to it.
Merci beaucoup. We'll move on to our second round of questions. We'll start off with Mr. Baber for 5 minutes. Please go ahead.
Good morning, Attorney General. I welcome the opportunity to discuss judicial appointments. Are you familiar with the appointment of Justice Matthew Piché-Messier to the Quebec Superior Court, yes or no?
When was the appointment made? Not off the top of my head.
Justice Piché-Messier was a repeat donor to the Liberal Party of Canada. His last donation of $12.50 was in spring 2024, and he was appointed to the bench in the fall of 2024. Do you believe that is appropriate, yes or no?
I believe that it should not influence one way or the other someone's appointment to the bench. There have been a number of appointments who've been involved with different political parties since I've held this position. I don't think the fact that you've made a donation to one particular political party should serve as either an obligation nor should it be something that bars you from being appointed.
In fact, 4 judges, or 20% of all judges appointed in 2024 to the Quebec Superior Court, donated either to the Liberal Party of Canada or to an electoral district association of the Liberal Party. That does not concern you?
If the allegation were proven that we were making appointments on the basis of someone making a donation, that would be concerning. There are judges who've been engaged with, as I've mentioned, various different parties who've made donations to different parties at different levels. That is not something that I seek information about before making appointments.
Attorney General, judges are appointed to the bench must be above reproach. That means that they must be devoid of any apprehension of bias. A donation to a political party is reflective of one's political ideology and therefore gives rise to an apprehension of bias. Lady Justice wears a blindfold for a reason. She doesn't favor red or blue. Will you commit not to name any past Liberal donors to the bench during your remaining time as Attorney General?
Look, it's essential that people are able to operate independently, but I think it's important that we don't exclude people from opportunities to serve Canada because they've engaged in our political process. With respect to Chief Justice Joyal, I believe he was appointed initially by a progressive conservative government at the provincial level, and to cast aspersions upon appointees on the basis of their participation in our democracy, I think may well violate someone's opportunity to take part in that democracy, including their freedom of speech. But more broadly, I would commit to not appointing people because they have made those donations, but I'm certainly not going to commit today to excluding people on the basis they've made a donation to the party to which I belong, or for that matter, to parties of a different affiliation.
The Justice Minister has significant influence over every judicial advisory committee. You appoint the 3 public members and you also select one out of the 3 choices given to you. At the same time, the judicial application form includes a question requiring applicants to express their views on the role of judges in a constitutional democracy. And I actually believe that the previous version was the role of judges in society. This is a leading question, Attorney General, that inevitably favors candidates with progressive leanings. So I'd like to ask you, is it appropriate for the Attorney General to make judicial appointments based on political leanings?
Well, let's not divorce this from the current facts. We are nominating a superior candidate who cannot be stuck neatly into a corner based on an affiliation with one party or another. What's important to me is understanding the character of the person. Do they have integrity? Do they have an understanding of the law, experience in the law? And do they understand the role that the courts ought to play within a country like Canada? When I see criticisms of reference to constitutional democracies, I don't know how that suddenly makes someone a partisan hack. My view is that someone, whatever their opinion is, having thoughtfully engaged on the philosophy behind how courts can engage in our democracy is actually a very healthy part of the exercise that informs appointments that we can make.
Minister, my comment was not with respect to the appointment before this committee, but to the question asked generally. And the question is, what is the role of judges in society? And I submit to you respectfully that it is not uncommon for governments to seek candidates that reflect their political ideology. That would be a question that could be derived and, in fact, allude to one's political ideology. And I'm wondering if you think that's appropriate.
Sorry, I don't share your concern, frankly, on the basis of a judge being able to discuss their role either in a constitutional democracy or in society more broadly is somehow leading to the appointment of judges who favor one political party over another. With respect, you said your question is not really pertinent to the conversation about the appointment of Chief Justice Joyal to the Supreme Court. That is why we are here. I question the relevance of your question if you're not able to stick to the very purpose this committee has gathered. In any event, I don't share your concern. I believe that ministers of justice, governments of different partisan affiliation are able to consider a person's perspective before their appointment as to the role of courts and judges in society or a constitutional democracy.
Thank you very much. That concludes your time, Mr. Baber. Moving on to Mr. Maloney for 5 minutes. Please go ahead.
Thank you, Madam Chair, and I want to add my thanks to the panel of witnesses today. Minister, Ms. McTeer, Mr. Giroux, thank you for all the work you've done in getting us here today, because this is an incredibly important process. It's an apolitical process, and we all owe you a debt of gratitude for doing what you do, so thank you. And I also want to add my thanks to outgoing Justice Martin, who served the court and the country with grace and an excellent display of legal knowledge, so thank you to her. Look, we've come a long way in terms of this process. Just so we're clear for the public, this is not a confirmation hearing like you might see in the United States. This is an opportunity for the Canadian public to become aware of what the process looks like behind the scenes in terms of appointing people to these critically important positions. we started back in, I think, 2005. The government of the day started the hearing process, which we're going to see again this afternoon. In 2016, we started with the process that you headed up, this time Ms. McTeer. And all of this is an effort so that the people in Canada can see how the process works, come to have further respect for our court system, which is above reproach, in my opinion. I practiced in Ontario for 20 years before going into politics, and just to briefly address Mr. Baber's point, not once did I walk into a courtroom and wonder who appointed the judge or what he or she did politically before. I think to suggest that that is a factor in decision-making or by judges is outrageous, frankly. And I just want to get that on the record. And that's why these hearings are so important, and what we're going to do this afternoon is so important. So maybe I'll just open the floor to all three of you to address that issue, because we've come a long way in this transparency process. And part of there's a big upside to it from the public, but as we've just witnessed, there can be a downside too, because it opens judges to commentary and criticism, which is political, unfair, and outrageous, in my opinion. And judges are not in a position like we are as politicians to stand in front of a microphone or put out a statement defending ourselves. We have the greatest justice system in the world, in my opinion, so I would just like you to comment on the process, on its pros and perhaps cons in light of what we just heard.
If I may, Chair, offer an initial response. I do find the line of questioning that we just heard to be deeply concerning. I don't want to make assumptions about motivation, but it seems clear there's at least some attempt to try to have Canadians question the independence of the judiciary based on their political affiliation. Just so Canadians at home have some comfort, for more than a decade, the process for all judicial appointments, not only at the Supreme Court, but every Superior Court appointment, including every one that I've made over the course of the past year, there has been an independent judicial advisory committee that has been struck, who is forbidden from considering the political activities of the applicants. They independently come up with a recommendation, either recommend against an appointment, that a person should be appointed, or give the highly recommended advice. And in my experience, and over the past 10 years, there have been 0 cases of a judge appointed who was not recommended or highly recommended by a group who was forbidden from considering the political activity. The independence of the process is essential to public confidence. Confidence is essential to faith in our democracy. It doesn't get more serious than this, and I really must draw attention and critique forcefully any attempt by any parliamentarian to call into question the integrity of the justice system. That is not a healthy thing for this committee to be digging into, and frankly is so far removed from the process and the facts on the ground that I think you're right to provide the platform for us to correct that perspective.
Limited time left. I wouldn't only say it's unhealthy, it's irresponsible. Ms. McTeer or Mr. Giroux, do you have any comments on the issue?
I would only reiterate the comments of that have already been made, that we have a judicial system that makes the envy of the world. People look to us. So we have my office conducts some international work, and people do come to us to see how things are done. How is the appointment process? How does it work? And while there may never be a perfect appointment process, the one we have is pretty solid. And never have I seen in my 20 years now in the office, I must admit, any appointment being made that is not from a recommended or highly recommended list.
Thank you. That concludes your time. Thank you, Mr. Maloney. Monsieur Portin, pour 2.5 minutes, s'il vous plaît.
Merci, Madame la Présidente.
Thank you, Madam Chair. So we're back. So I would like to talk about something. This is the 7th process since the 2016 reform to the nomination process. And we've also heard, and I don't want to show too much partisanship here, but ultimately, the Prime Minister makes the final decision. So the Prime Minister gets the Minister to provide a recommendation, a short list, and the Prime Minister makes the final call. This is possibly quite a good process, perhaps not, but the process has been used now for several times, and I would like to know whether you think there's any need to review any aspect of it or whether the process fits the mission. So it is part of our mandate to prepare a public report, and there will be recommendations in that report. And on the aspect of the process, we will have recommendations. I think something to keep in mind is you can't wait till the last minute. The contrast with what used to happen is that before the reform, we were constantly seeking out people throughout the country who might be suited to the position. And it's important to keep those people in mind when the time for nomination comes, whereas now it's different. They apply. I'm sorry to cut you off. I don't have much time left. And I'm really sorry, Ms. McTeer. I don't mean to be rude, but I have to keep going. Minister, you have been an MP, and at the time we talked about what your party called the Liberal list, people who had contributed to the Liberal Party or who'd worked for the Liberal Party during elections, so say the good friends of the Liberals. And that list had been used, and one of your predecessors told me that it had been used after an appointment to make sure there weren't any surprises hidden within. Can you tell me whether that list is still in use or not?
Database is in use by the Liberal Party of Canada. I have never used it during my process of making appointments. I will occasionally receive a note about a candidate after they've come through as being recommended or highly recommended. If they have a particular engagement we're aware of from any political party, I'm not always certain where that information would come from. For example, if someone made a donation to the NDP or a provincial Conservative Party, that would not be in Liberal list, so I'm not sure where the information would come from, but I will on occasion have a candidate's political activities flagged before a final appointment is made.
Thank you very much, Monsieur Fortin.
Merci,
That was an
Madame
extra
Présidente.
minute for you. Mr. Lawton, please go ahead for 5 minutes, sir.
Thank you very much, Madam Chair, and thank you to all of you for your work and for appearing here today. Ms. McAteer, I'll start with you. You had mentioned in your opening remarks, McTeer, sorry, you had mentioned in your opening remarks the importance of diversity for judges. And I just was hoping you could drill into what exactly that means. What diversity are you referring to when you talk about your process?
I think we probably all wish we did know whether it's just a check mark, this person fills a certain category or cultural identity or whatever, gender, or whether or not it's someone who has an inherent understanding through their life experience, through their professional experience, as to what in fact is the diverse nature of the country. And diversity can go well beyond the things we traditionally think of as being diverse in terms of an individual, to do they understand the nation? Do they understand the role of their role as a justice? That kind of diversity I don't think we've delved into as deeply as we have to what I call sometimes the checkmark notion of diversity. And in a country like Canada, I think that we do ourselves a disservice. We want, of course, and the Supreme Court, especially under this Chief Justice and previous Justice McLaughlin, have really worked hard to make that notion of that reality rather of diversity. So we have people from not just different areas of the country, but different types of background. I mean, the candidates we proposed were not just bilingual; they were trilingual, and so you have people who are still trying to work that out. But I think it's important that we have the visual of diversity and the reality of diversity across all kinds of different scales.
Is diversity of thought and diversity of perspective a consideration as well?
I think it's essential, of course, yes.
Was it part of your review process, and specifically
Yes, it was.
legal thought? Because we know there are a range of legal perspectives and ways that people approach the law. One of the concerns that has been raised by a number of scholars is that when Beverly McLaughlin was the Chief Justice of the Supreme Court, the court had a very elevated level of unanimous decisions. I think it was somewhere over 60%, which means that even on the bench, you weren't having sometimes that really strong dissent that could form the foundation of a future decision. And ironically, McLaughlin herself saw that with the Carter decision or Rodriguez decision and then the Carter. So was there an active desire to seek different legal approaches in the candidates you were searching, and where we might not currently have someone on the bench right now embodying and viewing the law that certain way?
I don't think we had that kind of discussion, no. Whether or not it's important, I think it's always important to have a broad understanding of what your role is. I think Justice McLaughlin did something. I spent a great deal of her time trying to get, what do we say, herd the cats, because independence among the judiciary is their number one point. And so to your point, that's why it is important that collegiality, for instance, be a part of it.
One thing I'll get to with you, if I can, Minister, about the role of the court and the role of judges. One of the outstanding legal questions, or at least one of the sources of debate, is who should have the final say? Is it the court or is it Parliament? Is it democracy or is it judiciary? And is that a consideration that you looked at in how the judge that you were going to support being on the Supreme Court would view that question?
Thank you, Mr. Lawton, for the question. So with respect to your preamble, my own view is that we're very lucky to be in Canada where the powers and constraints on those powers are actually outlined in the Constitution itself. And we can take our lessons not from saying there is one arbiter in one circumstance who is the final say and another in a different. There's a constitutional framework that spells it out with a high degree of certainty. And on occasion, there may be reasonable people who disagree. But to be clear on this appointment, there was not a single legal issue or perspective that determined or contributed to the selection of Chief Justice Joyal. To be clear, what is far more important to me than any particular opinion they may issue is, do they have the character and integrity and an understanding of how the courts can offer public services to Canadians. I think it would be very dangerous for a political actor to be seeking a judge who would make a decision in a given instance, when in fact we're dealing with people who have many years of service, who will be dealing with issues that cover a range of different subjects that may possibly be beyond our imagination today. So we are picking for character, for integrity, for deep understanding of the law and an understanding of the country in which the courts sit.
Thank you very much. That concludes your time, Mr. Lawton. Now moving on to Mr. Housefather for 5 minutes. Please go ahead.
Thank you very much, Madam Chair, and thank you very much to all of you for being here. And Ms. McTeer, to you and your committee, thank you for your work, and to Justice Martin, who I had the pleasure of being on the committee when she was appointed and asking her questions. Former McGill grad, of course. I appreciate her service on the court. I just wanted to say how much I appreciate this process, and I appreciate as well the lack of politicization that goes into appointments in Canada. For example, in the United States, we all know that in both 2016 and in 2020, President Trump said he would only appoint justices from a list selected by the Federalist Society. I mean, that is true politicization of the court. Here we have an independent process where a selection committee appointed by various different distinguished bodies across the country is able to ascertain of anyone who wishes to apply whether or not they merit being submitted to the Minister of Justice and then to the Prime Minister on a short list. And I think that is an incredibly good process. Ms. McTeer, in terms of the process itself, in the past, if I remember correctly, there have been 3 or 4 candidates that have been submitted to the Minister of Justice by the committee. Is there any reason you can explain to us why it was 2 this time versus the normal 3 or 4?
Yes, I can. We had extensive discussions, and we decided that those 2 who we were going to present were so exceptional that that was the decision, our consensus, that we would only nominate two. It wasn't a precedent. That was set the last time with when Mr. Justice McLaughlin made it clear, for the same reasons we had, that while the requirement was for three, there were really two so exceptional that they were the ones that would be best presented to the Prime Minister. Now, the Prime Minister, of course, as M. Fortin has mentioned, has the ultimate authority and could have returned to us and said, sorry, I want 3 to 5. And we would then have to give some thought, which would be very difficult for us, given we had already made our choice. But that didn't happen, as you know.
I understand. The only reason I raise this is, then the committee could one day say there's one candidate that is so distinguished and so much above everybody else that I am going to only propose one. That's why I kind of look at that, and I'm concerned, but I understand the point. Can I also ask, were you concerned about the fact that there were only 9 applications given in the past? There have been times that there have been significantly more applications?
It seemed low to me, given the vastness of the region that we were choosing from. It was, I think, if you've looked at the questionnaire, you realize it would take time to put together such a questionnaire. So time, and we're not saying anything new, other groups have said it in the past, the more time you can provide for this process, the better it is, not just for our work, but for the applications. And that's why one of the things I hope we can do is continuously look to see who are the best and the brightest in Canada, who are people who would be qualified, because the application process allows anyone, given a narrow, but still anyone, basically. If you've practiced law or even been a member of the bar for 10 years, you can apply to be a Justice of the Supreme Court of Canada. Maybe in terms of the application process, we need more time. We need perhaps more education across the bar. We keep more on the lookout, those kinds of things.
Question. I mean, I understand that you proactively interviewed the 4 final candidates in terms of in-person interview. You did enormous diligence based on their questionnaires. Did you also, I assume, do heightened levels of diligence with respect to things that they may not have disclosed in the questionnaire? I'm sure they were subject to credit and criminal checks and, and other similar types of publicly available open source information. But can you assure us that, whoever would be chosen, I'm not speaking of Justice Royale in particular, that this is, that it has been screened as much as a green light committee would screen a candidate for any of our political parties?
Well, we do that element based on the applications and our reading and our question and answer session. The rest of it is done by the Mounties. It's done by the those who have authority to do that kind of check.
One final question, if I may, Madam Chair, very short. Mr. Minister, could you just assure the court that, again, in the United States, there's often presidents who say we have to have an originalist, we have to, or a prime minister that might say we need somebody who embraces the Living Tree Doctrine, or a strict constructionist. Can you assure us that you did not put any kind of litmus test on the philosophy of the judge that you would have recommended?
Yeah, look, I'll entirely will endorse that perspective. I've put no such pressure on anyone through the process. Just maybe a comment to complete the answer. Some of the most beautiful things about the country in which we live are invisible to those of us who call it home. But when you actually start talking to people from around the world and they look at the protections that we have in place for our democracy, for our courts, for the independence of the judiciary and the rule of law more broadly, they blush with envy. Try attracting investment to a country where the judges are in the government's back pocket. It's not going to happen. We are very, very lucky to call Canada home, sometimes in ways we don't appreciate day to day.
Thank you, Madam Chair.
Thank you. Thank you very much, Mr. Housefather. Now we're going into our third round of 5 minutes, starting with Mr. Gill. Please go ahead.
Thank you, Chair, and good morning, everyone. Thanks to Madam McTeer and the entire panel. Thanks to Justice Martin for her service as well. Minister, you have acknowledged the alienation of both Quebec and Alberta before. Do you think the judiciary reflects the values and wants of those provinces?
The judiciary more broadly, or the Supreme Court of Canada? Not that the answer is different.
Yes. So do you think the judiciary reflects the value and wants of those provinces in Supreme Court of Canada?
Yeah, but I think we can always improve. Look, I've been on record in the House of Commons talking about the importance of regional representation on the Supreme Court of Canada since my very first year as an MP, now more than a decade ago. This is something that I care about. I think it's essential when we actually deal not only with Alberta, but Western Canada, that different parts of Western Canada see themselves represented on the court. I'm thrilled for Manitoba to be seeing this appointment. But we can't assume just because we have a person sitting on a bench that the values of an entire province or region, which are not monolithic in nature, by the way, are going to be represented perfectly in any one individual. We have to be vigilant as Canadians to make sure that we consistently consider the perspective of people who live in different parts of the country, and wherever we can, move forward with policy decisions that are going to serve their interests. But I think the court has a role to play in that regard as well.
So will you work with the provinces to give them greater say over judicial appointments?
So the two provinces you mentioned, I've had some significant conversations about what role the provincial government may play. I'm not interested in pursuing a constitutional amendment today during Mr. Joyal's nomination hearing. However, if there is a deeper degree of consultation that we can work with, that's something that I would happily have been engaged with and would happily continue those conversations with my counterparts in each province.
Mr. Joel seems committed to ensuring that Parliament has a greater say on constitutional issues. Are you committed to that too?
Parliament obviously has a significant say on matters of constitutional importance. I wouldn't suggest that Parliament has a diminished role today is the only issue I take with the way you framed the question.
And if I might, I just want to quote the Chief Justice here because this concern between the political and the judicial, I find almost sometimes a non-argument. But he said, ultimately, Parliament is sovereign. Parliament is sovereign. They make the law. Judges interpret, the courts interpret the law. And required is with respect to the Constitution to interpret it. That mandate was given to the courts by Parliament. So you can agree or disagree, or you can change the law. So there are elements. Parliament remains sovereign.
And Minister, do you think the judiciary accurately reflects the views of Canadians?
I wouldn't say that the views of Canadians are unanimous on any given issue, but I think over the course of our history, the Supreme Court has played an important role that largely aligns with the values of the vast majority of Canadians I've met over the course of my life.
And my another question to Madam McTeer, Canadians must have complete confidence that Supreme Court appointments are based on merit, not politics. Can you state confidently that Prime Minister's office had no influence over recommendations?
Well, I think people would be hard-pressed to determine to call me a Liberal Party hack. So, but also in terms of our independence, we had no discussion whatsoever with the minister or with the Prime Minister or any member of any political party, quite frankly. We were independent, we were an advisory group, and that's how we acted.
Okay, so you just mentioned the merit was the only criteria. So what measurable qualities made Justice Joel the outstanding candidate over every other candidate?
Well, in a judicial sense, the longevity and the importance of the cases that he had in fact heard and presided over in Manitoba as Chief Justice, his knowledge of the law, his in-depth and really far-reaching understanding of the role of the court as it relates to the needs of Canadians, but also respecting, if you will, the sovereignty of Parliament. He was fluently bilingual. He has traveled the world. He is a knowledgeable person. He is a good guy, I guess is what they refer to now, a man of integrity, and he just, on those bases alone, I should think.
Do we have more time?
You have 26 seconds.
Okay. So my quick question to you, so you committed, you never received indirect or direct guidance from ministers, political staff, or the Prime Minister office regarding the type of candidate they wanted, yes or no?
All right. That was a wonderful exchange right there.
Aren't you proud of me?
I am so, so proud. Thank you. All right. Now moving on to Madame Gladue for 5 minutes. Please go ahead.
Thank you, Chair, and thank you to our witnesses for being here today. I think you have a very robust process that is independent and as transparent as it can be, and I think you've definitely brought forward an exceptional candidate, so congratulations to you on that. One of the things I wanted to talk about was with respect to the process. And so, Ms. McTeer, you spoke of time constraints, and I see that the application process was only open up for 28 days. So how does somebody who's a judge or a lawyer with 10 years of experience, how do they find out that the application process is open?
Well, through the media, in a sense, you would have learned that Madam Justice Martin was stepping down. And then you'd get your computers organized to put together the long, extensive pieces of information that you would need. Some people, perhaps, had even begun that process long before. We also know when you reach 75, you're going to have to step down. So then it also gives you an idea of when the next process, if you will be happening, and so you can begin to get your ducks in a row, if you will, if you're considering an application. So I would think, but regardless, I still think more time is very important. That's one element of it. The other element, I think, is also the seeking out, knowing beforehand that there are qualified people from that region who are intriguing, and perhaps not the committee itself, but others who are involved in the process, encouraging them to apply.
Excellent. I know that I had heard a concern from Saskatchewan that they haven't had a Supreme Court justice in, I think, 53 years. But were they open for these applications in the West?
Oh, yes. I mean, anyone who lived in the regions called West, as defined, the Western provinces in the North, could apply. That's basically, I think, really how it should be. But again, if there's more, I shouldn't say organization, but more time, if you will, for people and more encouragement, I think that the Canadian Bar, the various associations, should have a responsibility to encourage their members who are qualified to be applying for this.
This was exactly my thought, that there's an opportunity to do a better job when the applications are open of letting candidates that would be worthy know that it is. And I'd be interested in your perspective on what kinds of improvements you'd like to see. How much time would you recommend for the process to take? Do you have any other recommendations having gone through this? And I would ask the same question to Mr. Giroux, who's been here for 20 years.
Well, we have a mandate to prepare a public report, and you will have that before Parliament resumes in the fall. And I do not want to. I mean, I obviously have some ideas, some views, which would startle people if I didn't. But I think, out of respect for my colleagues, that once we've had an opportunity to speak, that it would be much better if those recommendations, and there will be recommendations, are part of that process once we've had a chance to discuss. And we operate by consensus, and so I would prefer to respect that consensus.
Absolutely. Mr. Giroux.
Thank you, Madame Gladue. I would simply state that as soon as the application process was started, as soon as the announcement was made, I personally wrote to 73 legal and judicial organizations throughout the country, including out west, obviously, and up north, and inciting and inviting them to encourage candidates from their various organizations to apply. Obviously, some people may have other reasons why they don't want to apply. They may not want to move to Ottawa. They may enjoy what they're doing. And out of the 9 candidates that did apply, it's not a very different number than previous processes. And in consideration of the fact there was one only 3 years ago as well from the same region, and people were given 28 days, which is again pretty much within the average of time allotted for the most part for previous processes.
Excellent. And just quickly, from a diversity perspective, you spoke of how, the check boxes work. You spoke of how we need to have a diversity of experience in different areas of the law. Is there any kind of guidelines for the advisory councils to use in order to make sure that we do have a balanced Supreme Court?
Not that I'm aware of. I mean, do you, Monsieur Chabot?
No, I would simply state that obviously the appointments are first of all made on the basis of merit, but within the criteria that are set for the Independent Advisory Board, diversity is one in that obviously the court should reflect as much as it may Canadian society, not only the Supreme Court, but within all of the superior courts across the country. And obviously steps have been made that is more of a reality now.
Thank you. Thanks very much, Madame Gladue. Monsieur Fortin, please go ahead for 2.5 minutes, sir.
OK. Merci, Madame la Présidente.
Thank you, Madam Chair. Minister, we were talking about this earlier. Ultimately, the Prime Minister makes the final decision. Advisory board members have a recommendation and present candidates, but the ultimate decision seems to be made behind closed doors. I also think it's important that Canadians trust in their judicial system. I think that the courts are the backbone of democracy in many regards. I also disagree with the way that this has been characterized earlier during the hearing, but given that the system happens rather behind closed doors and there isn't any debate, Minister, do you think that there is a different way that we could use? Having used the current system for a number of years now, could there perhaps be a debate in Parliament prior to a nomination? Could provinces be consulted? Could there be ways of making sure this decision is no longer made behind closed doors and that there is greater participation in this process?
Selon moi, le processus.
So I think that the process we have is working. It is producing excellent candidates. Now, with respect to what you said about this being behind closed doors,
The appointment hasn't been made. This is an act of public accountability and transparency in the decision-making process, which is a far cry from having the process completely finished before there's an opportunity for anyone to raise concern. I would always entertain ideas on how processes could be improved. I worry sometimes that taking things to a debate that must be adopted in the House could potentially turn what has historically been an independent process into a very political one. But if there are other ideas, I would not suggest that the process can't be further
Si vous
improved.
permettez en quelques secondes pour Madame Mectier, le
if you
rapport.
just give me a moment for Ms. McTeer, the report you're going to publish, when's it coming out? Do you have an idea? I think it's in about 6 weeks. 1 month to 6 weeks is when we're planning to publish it. Of course, all of the board members are extremely busy over the summer, as you can imagine, I'm sure.
Moving on to Mr. Brock for our last 5 minutes. Please go ahead. 5 and 5.
Thank you, Chair, and I'll be splitting my last 2.5 minutes with Mr. Lawton. Minister, were you and the Prime Minister at Edom with respect to this justice that has been chosen?
Only because when I give advice to the Prime Minister, I view that to be his information to share or not share. I can tell you I'm very, very comfortable with the selection that he's made in this process.
Thank you. So to Ms. McTeer, the example I had previously provided to the Minister about Justice Yoel's application in 2019, which was ultimately rejected because Justin Trudeau found something offensive in a public statement. What would have happened in this particular case if the Attorney General made a recommendation for Justice Yoel and Prime Minister Carney rejected that? Would that have ended that particular candidacy?
I don't see why not. I mean, the Prime Minister is, has been stated by many of you, the final arbiter in this.
Okay.
Our job was to present the best options. And at
So
least
he has the right to veto.
well, I should think. I
Yes.
mean, yes, he has.
Okay.
He has the right to do it, even if he doesn't like what we have
Sure.
done.
And the last question to you, Ms. McTier, is I often lament upon the forced retirement of Justice Michael Moldaver, who I always had viewed as the dean of criminal law in this country. I still refer, when I was a practicing Crown attorney, I referred routinely to some of his decisions at various levels of court. Was there a specific need during the consultation process to find a candidate with superior criminal law and constitutional experience? Because it would appear, according to the bio of this particular justice, that he certainly fit that bill.
We heard from the Chief Justice that that was one of the essential criteria. The court needs to have this. I don't think anybody can substitute for Justice Moldaver, but that was actually very, very important in the consideration.
Thank you very much. Mr. Lawton.
Thank you. So this has come up before in the conversations we've been having today, this idea that the judiciary and judges need to be above reproach. But as we know, there also needs to be the perception and vision that it is above reproach. And I want to ask a bit about expectations when it comes to recusal and how judges are to navigate conflicts or perceived conflicts. Is this in the screening process and in the interview process something that's broached with candidates of how they will navigate issues where they may have a conflict or a perceived conflict?
That was not raised, no, in these.
Should it be, in your view? Because this has actually come up quite recently in public discourse surrounding the Chief Justice and how he is to reconcile public statements he's made on an issue with a case coming before the court. Is that not a relevant barometer of how a judge would approach the office?
I don't think so. I really don't think so. I think we are looking at people of the highest moral character, and also we have to trust a bit to their own judgment and decision-making. There is an attempt, or seems to have been an attempt, to politicize the courts. I think we have to be careful. The courts are not there to basically do what politicians want. Parliament is sovereign. Parliament makes the laws. All the judges do is interpret the law. With respect to recusing yourself, if it's so outlandish, then of course there should be objections made. But generally speaking, they're not eunuchs. The members of the Supreme Court, they have opinions and views, and especially if it's something that was said before they even became, I think that's even more unlikely that they should be tempered or affected by that.
Share that view, Minister, that how a judge will approach potential ethical questions or conflicts of interest is not a relevant consideration in the interview process or in the vetting process of a potential Supreme Court justice?
Well, I think the issue of a reasonable apprehension of bias would be so heavily fact-dependent. I wouldn't necessarily think you would be able to uncover it in a general way through a process that's considering a person's character and integrity more broadly.
Justice, how they navigate those issues, you don't think could be done without a fact scenario?
Well, look, in the absence of a fact scenario to draw upon, with respect to Monsieur Joyal, for example, I can't think of an item other than judgments that he may have issued that are currently in an appeal period, which would be obviously a very different set of facts than you're thinking of. So I struggle just to see, without a huge objection to recognizing that you should make sure that there's not an apprehension of bias when you're taking a decision. I just have trouble figuring out how that would fit into the consultation process, given the very fact-specific nature of any claim of bias.
Thank you. Thank you very much, Mr. Lawton.
Madam Chair, if I can just add, if in fact that is going to be something that this committee feels is important, it is certainly something in our public report that we will give some thought to.
Thank you. Thanks very much. Now moving on to our last 5 minutes. Ms. Dillon, please go ahead.
Thank you, Madam Chair. I'll be sharing my time with Mrs. Begum. So I will start with Mrs. McTier, Mr. Giroux. We know that confidentiality is a large part of this process. And the question is, with this confidentiality, how can we reconcile disclosing also to Canadians what goes on behind the process of selecting a judge, to have transparency. Can you please tell us about this balance a little bit?
Well, I believe that confidentiality is not just important. I believe it is at the heart of the process. And so respect for the confidentiality, I think, will also affect the number of people who are willing to apply, because these questionnaires are very specific. They contain personal information, a lot of personal information, which no one has given permission be in the public domain. So there's that element. But I also think, because we're an independent group, that there reach a point when, if confidentiality is at the heart of what we're doing, then there has to be an understanding by the public that we are free, if you will, of political bias or other biases. And I think that's probably why we were chosen. And it's not the government that chooses us. It's the Canadian Bar, it's the Indigenous Bar, it's the Federation. There are a series of groups, the Judicial Council, who are the ones who present the names. And so I just feel that you can only go so far, and the right to know, if you will, the interest in knowing. I don't call it a right. I think we use that term, willy-nilly all the time now. But the interest of the public interest in knowing is in being able to trust that it is an independent process, and that's the best we can actually offer, is to make that commitment.
Thank you so much. I think there's time just for
Mrs. Begum, please go ahead.
Thank you very much. Thank you. I'm glad I have an opportunity to, sort of follow up on some of the conversation. And as someone who wears many hats as a member of a diverse background, I think true diversity of thought really transcends more than tokenism or the checkmark that Ms. McTeer spoke about. And I think it really relies on deep, meaningful experiences. And given that track record of Justice Joyal, and what we've heard from this morning, it really shows that depth. And just kind of learning about Justice Joyal's experience, as well as the work in terms of whether it's Francophone or I'll just take a moment to quote the Assembly of Manitoba Chiefs remark in their news release that said, and I quote, "For many years, Justice Joyal, he has demonstrated that the administration of justice is strengthened when courts are prepared to listen, to learn, and to build respectful relationships with First Nations." And that's just one of the many validators who spoke so highly about Justice Joyal's experience and his balanced approach, his wisdom, his open-mindedness. I wonder if one of the three of you could speak to that depth of knowledge, that diversity of experience and thought.
Look, very quickly, I sense we'll have very limited time left. We're dealing with somebody who's got experience as a Crown prosecutor in the private sector, 3 decades on the court dealing with matters of criminal law, of constitutional law. In addition to the experience sitting in a role as judge, we're dealing with someone who's given so much of his personal time towards the profession and towards the judiciary more broadly, serving on committees with the Canadian Judicial Council, serving in a capacity, in my experience, on the Courts Modernization Committee to help improve the processes for all Canadians. You pick up a lot of life experience along the way, working not only with I think it was the Assembly of Manitoba Chiefs that you referenced. There is a list as long as my arms, and I am 6'7", of people who are willing to endorse Chief Justice Joyal to be the next Supreme Court Justice in Canada. It's that depth of experience that justifies his appointment, and I think we're moving in the right direction. And I take it from the comments from different members today that there's widespread agreement on that point.
Excellent.
Thank you very, very much. Je vous remercie pour votre participation.
Thank you all for your participation today
in helping us and Canadians understand the process. Ms. McTeer, thank you so much for your hard work. Monsieur Giroux, I really appreciate it. Mr. Fraser, as always, it's a pleasure to have you in this committee. I thank members for your engagement today, and I will remind you that at 1:30 p.m. we will be having a question and answer session with the Honorable Justice. that I'm really excited to participate with all of you in. We'll have the Senate committee as well as our Justice Committee that will be participating, and I will see you then. Meeting adjourned.